Judicial.
ladies and gentlemen.
Please, Your Worship. My name is Michael. I'm appearing. First accused person, jointly. Mr. Miracle.
Yes, Your Worship, that is very true. I appear for prosecution. A2 is not represented, and this matter is coming up for further mention. Our investigations, Your Worship, are still on the go. They are going on smoothly, Your Worship, and at the same time we're expediting them to ensure that the accused persons are committed to high court. Last time I overheard my senior colleague put up disputed fights, but our inquiries are going on smoothly and we are mindful. So in the circumstances, we seek an adjournment to enable us to complete this.
Please have flashes of the video distract.
charged before the General Court Martial in 2017 in similar allegations. I spent a total of 5 years in matching the military prison. I was later exonerated and set free. 4 years later, similar allegations have been brought in this criminal court of Nakawa. From the time I was first produced, the state has been going, giving the excuse that inquiries are ongoing and that still going. The alleged offense occurred in 2015, more than 10 years ago. The state has been investigating this case for more than 10 years. I can now see the same pattern emerging of people being custody while the state engages in endless investigations and inquiries. If the state is not ready, I should be released immediately. I should be released unconditionally. If they are complete, if they complete the inquiries, I'm ready to defend myself at any time. Otherwise, this conduct amounts to prosecution. As of now, I was spent in custody a total of 105 days without trial. This is injustice and persecution, and I pray that the state be urged to complete the investigations expeditiously, or if they cannot do so, release me unconditionally. This is my conclusion.
The last time we appeared before you, directed to file notice of instructions, which we did, and I believe a copy is of the court report. Since the accused was first brought before court, he has been requesting to be furnished with the formal judge copy. He has not been furnished with such a copy. And yet we know that in criminal proceedings, without charge sheet, the accused person is not able to know the allegations against him, and is also not able to formulate his defense. So in your premises, Your Honor, it is my humble prayer that the state be ordered to furnish the defense with a copy of the charge sheet or indictment for that matter, in the interest of justice. We so pray.
Please have flashes of the really described
To say.
I have complaint to make for you. I was arrested and charged before the General Court Martial in 2017 in similar allegations. I spent a total of 5 years in matching the military prison. I was later exonerated and set free. 4 years later, similar allegations have been brought in this criminal court of Nakawa. From the time I was first produced, the state has been going, giving the excuse that inquiries are ongoing and are still ongoing. The alleged offense occurred in 2015, more than 10 years ago. The state has been investigating this case for more than 10 years. I can now see the same pattern emerging of people being in custody while the state engages in endless investigations and inquiries. If the state is not ready, I should be released immediately. I should be released unconditionally. If they are complete, if they complete the inquiries, I'm ready to defend myself at any time. Otherwise, this conduct amounts to prosecution. As of now, I was spent in custody a total of 105 days without trial. This is injustice and persecution, and I pray that the state be urged to complete the investigations expeditiously, or if they cannot do so, release me unconditionally. This is my concrete motion.
Worship, the last time we appeared before you, directed to file notice of instructions, which we did, and I believe a copy is of the court report. Worship, since the accused was first brought before court, he has been requesting to be furnished with the formal judge copy. He has not been furnished with such a copy. And yet we know that in criminal proceedings, without charge sheet, the accused person is not able to know the allegations against him, and is also not able to formulate his defense. So in your premises, Your Honor, it is my humble prayer that the state be ordered to furnish the defense with a copy of the charge sheet or indictment for that matter, in the interest of justice. We so pray.
Was charged by the General Court Martial. We are not aware of any proceedings before the General Court Martial. Has the current charges before you, Your Worship?
A minute, please. Just a minute. They're going to translate for you. Just be patient here.
Omwa gavumenti agambye nti nno oli emisango gy'abadde agamba gye bamuteekako court martial nti bo abadde tebagimanyiiko.
So we translate.
Yes. Which the accused person and his colleague are facing before you.
Nti bo bamanyi gino emisango egiriwo olwaleero.
It is immaterial whether Your Worship this matter has been under investigation for 10 years. What is important is that investigations are still ongoing.
Ekikulu kiri nti bakyanoonyereza ku musango guno.
Even if the accused person had the charges before the General Court Martial.
Wadde munna agamba nti nno waliwo omusango gye bamuteekako mu court
If they had
martial.
no control over those
charges.
naye bo abasaidde ebyomwana
And those charges have no space in the kind of charges which the police persons are facing.
Ebisango tewali ngeri bwekwataganya nagye mu kujakati.
And as far as we know, you're facing charges of murder, and you have been on remand
Wakati wakutemula era baddeyo ku remand
for not more than 6 months.
nawezayo emyezi 6.
Merely, the fact that you have not been committed before those 6 months
Okubeera nga tebanaba kubaweereza ku kkooti enkulu ng'emyezi mukaaga
has no connection with the persecution. We are not, the prosecution is not persecuting you anymore.
tebali mu kuleeta bujulizi saawa zino.
We are not persecuting him as he alleged. The charges against him are based on facts, evidence, and the law.
N'amateeka nga bwegagamba.
So it is therefore premature for you to submit or to ask court to release you unconditionally.
Era temunatuusa kusaba kkooti kubakkiriza kuteebwa.
Good enough you were in this system before. You know the process very well. Yes, I am. Yeah, it is relevant here, my lord. Your worship. Very relevant. We are still within the 6 months, sir. And this is just to inform court that we shall abide by the 6 months, and we shall finish up those investigations before those 6 months. If our investigations are complete next week, we shall commit you before even the 6 months elapse. In regard to your worship with the charge sheet, I remember vividly that we gave a copy of the charge sheet for accused persons. But whichever way you worship, this one doesn't require. My senior colleague knows it very well. We have appeared with him. Should have just told me, Richard, I need a copy of the charge sheet. It doesn't require to West Court's ink to order because there are some of these rights which are not. So we shall therefore avail defense with a copy of the charge sheet. I think immediately after here, we will make a copy for him. We so pray, Your Worship.
Now to try. Worship, I wish to state that that is not backed by the law. The law, as I understand it, is that before you arrest someone, you must have sufficient evidence to warrant prosecution. It is inconceivable that in a matter, a high-profile case like this, you can arrest and start investigating. Because there is then a possibility that after the 6 months, they may find no evidence, and then the person is released from custody. So the state must be mindful of that time where the accused person is in custody. And like he said, we have all along been ready for trial. If they are ready, let them commit the accused person for trial rather than to hold him indefinitely. So we pray that the state should expedite their inquiries. Especially when the state comes and the Honor does not give at what stage the inquiries are. Are they preliminary? Are they advanced? At what stage are they? So the hearing of this matter, because the accused person is entitled and expeditious hearing. So
Is it also in relation to being previously charged before the court martial?
okutta kagezi nga bangamba kayuula ne kagabe bantuma ngenezite kagezi.
Just a second. What I want to understand is your concern related to the fact that you two allege that you were before the court martial. Because I want to address that. Okay, so I'm going to address that.
I am going
to address that. Let us stick to Mr. Abdul. Mr. Abdul, this court has no jurisdiction to hear the nitty-gritties of the case before this court. So allow court to respond to the concerns that have been raised.
Okunnyonnyola ensonga gye ndiko nti ndi wano lwakagamera kayugula nga bantuma mu nzite kagezi n'abasiraamu kagamba ajjeko gavumenti ya Museveni.
Like I have said, this court has
ekibuga ekira wano mu kkooti yakagamera kayugula. Ndi wano lwakagamera kayugula nti bantuma nzite abantu kagamba ajjeko gavumenti ya Museveni bye bankubiranga mu Safe House.
Mr. Abdul, for me to be able to help you understand what this court is mandated to do, you need to be able to listen. This court has no jurisdiction to hear the nitty-gritties, the facts relating or the alleged facts relating to this case. Whatever you want to say in relation to this case will be said before the High Court. So allow me finish, please. Yeah. The issue of being allegedly being charged before the court martial, I am going to pronounce myself on the same. So can I now respond to you, please? Mr. Abdul, I will not let you disrespect. Mr. Abdul, please allow court to respond to you. I have taken note of the concerns raised. I note that these very concerns were brought to the attention of court on the last date. And this court pronounced itself in the same. I noted that any concerns relating to having previously been charged before the court martial or not can be brought before the court with jurisdiction. And I guided that is the High Court. An application to that effect can be made. I have already pronounced myself on that. On the question of the length of investigations, I equally pronounced myself on the same issue on the last date. Yeah. I noted that you put in a request for a typed record of proceedings. And the record is ready. You can be able to pick it immediately after court. Concerning the issue of the charge sheet, it is not true that any request of that nature has been made to court before and has not been honored. Nonetheless, a copy of the charge sheet will be made available to your advocate and to the to A2 who is not represented immediately after court. The state is reminded to hasten the investigation so that you can be able to commit. That said, this case is further adjourned for mention to the 17th of September.
Seek the indulgence because 23rd and 24th.
Can you have 18th?
We shall send for you on the 25th.
I handle cases on remand on Wednesdays, so we can have the 24th of September.